So good evening all. I hope till this point we have covered this drafting of plant, writing of plant, the rejection of plant, the parties to the suit, framing of the suit. So order 1 to 4, and then this order 6 and 7. And then we have started discussion on suit of civil nature. Suit of civil nature. So I hope till this point you have done and you have started solving question also. So whichever question you are not able to solve and not able to get correct answer, please let me know in your WhatsApp group. Not individually, personally, but in WhatsApp group only. Is this all right? And in question answer session, we'll have question answer session separately also. We'll solve all those questions, but if you write in advance, you will get better answer, better reference. So WhatsApp group, I have told you 9 to 9:30 in the morning, 9 to 9:30 in the evening, you can drop your questions and I'll answer it in the next class. So section 9 we have done regarding this suit of civil nature. Now then, we are going to discuss another topic related to jurisdiction of civil court. One jurisdiction is jurisdiction relating to subject matter. And then there is another jurisdiction related to territory and jurisdiction related to pecuniary things. So basically when I say jurisdiction, I refer to three important things. But what is this jurisdiction all about? Yes, happy Diwali, happy Chhat, happy day, happy CPC, everything happy, happy. All things should be happy, happy. So as far as this CPC is concerned, I think that you feel happy in the class and you feel happy in the understanding. No? And if you do not understand anything, please let me know, I'll make it clear again. So today we are going to discuss this concept of territorial and pecuniary jurisdiction. So in that regard, first and foremost question is, what is this jurisdiction all about? Now, as I appreciate and understand in very simple language, jurisdiction is basically competency or authority or power of the court to decide a matter. It is competency, it is authority, or it is the power of the court to decide the matter. So which court is competent, which court has power and which court has authority, that is the question to be answered. So I said, what is jurisdiction is first question, and what kind of jurisdiction? So jurisdiction is basically competency, authority. Subject matter jurisdiction, pecuniary jurisdiction, territorial jurisdiction. Now, subject matter jurisdiction is there in section 9, which we have already read, and we read it in great detail. We discussed there that the court shall try all civil suits or suits of civil nature unless and until it is either expressly or impliedly barred. So that is one point, subject matter jurisdiction. Pecuniary jurisdiction relates to the value of subject matter, and depending upon that we decide the competency of court, the lower court, the higher court. That is how we decide. And different states have different pecuniary limits of jurisdiction. Different states have different limits of pecuniary jurisdiction. So that point is there in section 6. If you look into section 6, what does it say? And you can see section 15 also. So let us see section 6 and section 15 on that point. Save in so far as is otherwise expressly provided, nothing herein contained shall operate to give any court jurisdiction over suits the amount or value of the subject matter of which exceeds the pecuniary limit of its ordinary jurisdiction. So it says save in so far as it otherwise expressly provided. So if it is otherwise provided, then that will prevail. Special prevails over general. Meaning thereby, except in those cases where something is expressly provided that this court will have jurisdiction or that court will have jurisdiction, that will prevail. Otherwise, nothing herein contained shall operate to give any court jurisdiction over suits the amount or value of the subject matter of which exceeds the pecuniary limits. So it gives the idea and hint that we fix the pecuniary limits of court, and it is different in different states. Depending upon the value of property, they will decide the pecuniary jurisdiction. So that is state-wise. So if you appear in any exam of a particular state, you should know of that. I have given few examples in your this Bear Act also. That is pecuniary jurisdiction of suit application and cases presented to district judge, additional district judge, senior civil judge, and judge of a small court of Delhi is as under. A small cause 5,000. Senior civil judge or civil judge, this is up to 5,001 to 3 lakhs. And then district judge 3 lakhs to 2 crores. And then 2 crores, above 2 crores, it is high court. It is high court. And for commercial matter, it is 1 crore and above. So this is basically now different states have different standards and different parameters of deciding this pecuniary jurisdiction matter. So that's a state-wise question, and not important for exam as such, but it is important for you to know as a lawyer or as a judge that which jurisdiction you can exercise. Now the main question is about now territorial jurisdiction, with which we are concerned right now. Territorial jurisdiction. Territorial jurisdiction. Is this all right? So in this territorial jurisdiction, place of suing, now section 15, 16, 17, 18, 19, 20 basically, and then there is objection as to jurisdiction. Objection as to jurisdiction. So we'll be covering this. So let us start with the first point, that is territorial jurisdiction, particularly section 16 to section 20. Section 16 to section 20. Every suit, section 15 says first, every suit shall be instituted in the court of lowest grade competent to try. So this is one direction of CPC, that every suit shall be brought in the lowest court. Shall be brought in the court of lowest grade competent to try. Every suit shall be brought in the court of lowest grade competent to try. So the lowest grade court. Now why this is the rule? This is the rule based on convenience and practicality. The convenience is that if you go to lowest court, you will have less expenditure. It is easily approachable. It is available at local level, and that is why it is practical also. It is practical that you should go to the lowest forum first. If everybody starts approaching the highest authority, then how the matter will be resolved? Because highest authority will have various cases and various things at their hand. So that is not proper, that is not reasonable, that is not acceptable, and that is why this rule of convenience and practicality, that you approach the lowest authority. Now you can take example like this, that if you need material and you start asking me, so will it be possible for me to supply you material? The answer is no. I can prepare material, I can prepare barrack, I can answer your questions, but I cannot supply you material. For that there are different people to work upon. So it is not reasonable also. Is this all right? So that is how we have written this. Nothing great, but see the word of emphasis and prescription here. Every suit shall be brought in the court of lowest grade. Shall be brought. So there is command, there is mandate. Shall be brought in the court of lowest grade. So suppose if you go to court of higher grade, then they can give judgment, no issue. They can give judgment. It is an irregularity. It is an irregularity because it was not regular and proper to approach higher authority for this purpose. But if it is other way around, if the jurisdiction is of higher court and you go to lower court, and then lower court cannot decide such matters. This will be now a nullity in that sense. You do not have jurisdiction and you are deciding a matter. So in that case it will be null and void. This is same in CRPC also, in criminal law also. You should not go to that court, or you should not go to that authority which does not have jurisdiction. This is not proper. So section 15 has a very simple import and very simple thing to state, and that is, I hope, is very, very clear to you. And section 15 is one of the most fundamental rule of jurisdiction. Now if you see section 16, suit to be instituted where subject matter situate. So that is very simple, general again. Now wherever the subject matter is there, it is easier to execute the decree after judgment. Now in this context, I would like to quote fundamental rules of jurisdiction first. So you can note down them one by one. Fundamental rules of jurisdiction. Fundamental rules of jurisdiction. So what are the fundamental rules of jurisdiction? So first fundamental rule is, every suit shall be instituted in the court of lowest grade. Every suit shall be instituted, first fundamental rule. Every suit shall be instituted in the court of lowest grade. Having jurisdiction in that matter. Every suit shall be instituted in the court of lowest grade having jurisdiction in that matter. So we are required to see which court is the lowest court. Like in Delhi, if the suit valuation is of 1.5 crore, then you cannot go to any court, but you will go to district court. So that is the court having now jurisdiction. So that will be instituted in district court, which is lowest court for this purpose. But if the suit is of value of 2.5 lakhs, then the civil judge can decide that matter. No requirement of district judge. So that is the law on the point. Every suit shall be instituted in the court of lowest grade, having jurisdiction in that matter. This is first fundamental rule. The second, where subject matter, the court where subject matter is situate, the court where subject matter is situate will have so this is subject matter jurisdiction. Where? The court of that place will have jurisdiction. The court of that place will have jurisdiction. The court where subject matter is situate will have jurisdiction. The court where subject matter is situate will have jurisdiction. Third, if cause of action arises at one place, if cause of action arises at one place, then suit shall be filed at that place. 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 Next, if property is situated at different place, like you own various properties and it is lying at different places, and that is to be partitioned. Suppose you and me are co-partners in a family, and our property is in Delhi, our property is in Gurgaon, our property is in Noida. So property is situated at different places. At different places. Then the courts of that different place, that is all Gurgaon, Noida, Delhi will have jurisdiction. Of that different places will have jurisdiction. Will have jurisdiction. Similarly, if cause of action arises at different places, then the different courts of those different places will have jurisdiction. Will have jurisdiction. Then next, in case of uncertainty, in case of uncertainty, in case of uncertainty, in case of uncertainty, in case of uncertainty about in case of uncertainty about jurisdiction of courts, we can file case in any court in case of uncertainty about jurisdiction of courts, we can file case in any court concerned there. Uncertainty, it is not clear whether the jurisdiction lies in this court or in this court, A or B. So you can file case in any court concerned there. Now I have doubt, but I think that A should have jurisdiction. But I should have justification for that. So you can file case in A. But somebody believes that no, it should be court B, so he can file case in B. After all, the court will decide which court has jurisdiction, that's a different matter. But you must know that primary purpose of the civil law or any other procedural law is to facilitate the remedy. It is not to prevent the remedy. So we will not make a rule which will prevent the remedy. It requires liberal interpretation, because the purpose of law is to provide justice, no? And fair trial. So for that justice, for doing of that justice, we are required to be flexible. We are required to be flexible, and this flexibility requires that the law should allow him to file case in any court, provided he should have a reasonable explanation there. So that we'll see in the provision, don't worry. Section 17 is about uncertainty. Section 17 is about uncertainty. So these are the fundamental rules. Now let us see the specific provisions and let us understand these fundamental rules in a specific provision. So let us see first and foremost section 16, very important. What section 16 says and what it does. It says suits to be instituted where subject matter situate. So you can raise a question where property related suits will lie, or where suits related to immovable property will lie in general. So raise questions where suit relating to immovable property will lie in general. This is one question. The second, whether the suit relating to property lied at the place where it is situated. Yes, yes. So rather than raising another question, let us address this and let us understand the answer to the question. So it says subject to pecuniary and other limitations prescribed by any law. Pecuniary limits should be satisfied, whether it is junior court or senior civil court or district court or high court, we'll have to see this. Subject to pecuniary or other limitations. Other limitations may be, now you know about various limitations which is imposed in law. Res judicata is there, res sub judice is there, limitation restriction is there. It may not be suit of civil nature, that may be there. It may be expressly or impliedly barred, it may be there. So all those restrictions, it says subject to pecuniary or other limitations prescribed by any law, suits for recovery of immovable property. So suits for number one, a recovery of immovable property. With or without rent or profits. It is suit for recovery of immovable property. You want to recover immovable property where you have been dispossessed or where you have some rights but you are not given, with or without rent or profit. No, you have given it on rent, so you claim the rent also. It is leased property. You have given it on lease, so you will obviously claim rent or profit. Somebody has been in unlawful possession or occupation, so you may claim mean profit along with recovery of immovable property. So all such suits will lie at the place where property is situate. So suits for recovery of immovable property with or without rent or profits will lie at the place where property is situated. Where property is situated. Then second it says, for partition of immovable property. 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 So write down number 2. Suit for partition of immovable property. Suit for partition of immovable property. So partition is there, but partition of what? Immovable property. So it is always better to file a suit at that place where property is situate, without doubt. Number 3, so it doesn't require any clarification. Suit for foreclosure, sale or redemption in case of mortgage or of charge upon immovable property. Suit for foreclosure, sale or redemption in case of mortgage or charge. Foreclosure, where you foreclose somebody's right to get back his property. Foreclosure. Suit for foreclosure, sale or redemption. Foreclosure. Now, when you take loan by mortgaging your property, the party who has the possession of your property in case of mortgage, he can foreclose your right to get back the property. That is what is called foreclosure. Because you have not been paying the loan or you did not pay the loan, so he may obviously deprive you of your right to get back the property unless and until you pay the loan. Sale, obviously, if you do not pay the loan, how will they recover their money? They are not interested in your property, so obviously they will go for sale. Or otherwise also there may be now suit for sale of property. Redemption where you as now mortgager, you have mortgaged your property to mortgagee, that is bank. Now suppose you have taken loan from bank, so you have mortgaged your property to bank. So bank is mortgagee and you are mortgager because you mortgaged your property, mortgager. So you have right to get back your property, so redemption. So suit for redemption, foreclosure or sale will lie in case of mortgage or charge upon immovable property. Mortgage is basically now a kind of secured loan. You have given your property and they have given you loan in against your property. So charge upon immovable property. And what is charge? Charge is a kind of right which is created over property, that whatever benefits or whatever earning this property will have, that will go to you. So charge is created in your favor. You just understand it in your language right now, in simple language. Charge is a kind of right created over a property whereby you have been given authority to receive the profits, receive the earning of that property. So that is what is charge. It is also used as a kind of security in that sense, that see, I have given you benefit over this property, that whatever income is there of this property, you will get that income. So charge, that is what is called charge. So this suit for redemption, mortgage, foreclosure, sale, or this charge will lie at the place where immovable property is situated. Where immovable property is situated. Suit for determination of any the right to or interest in immovable property. Suit for determination of any other right to or interest in immovable property. So after all, it is related to immovable property. Suit for determination of any other right to. You may have right to pass through that property. You may have right to receive some benefit of that property. Or you may have some interest in that property. Whatever interest you may have in that property, interest may be to interest to obtain some benefit out of that property, maybe recovery of rent, maybe interest in form of possession of that property, maybe interest of that receiving some profit out of that property. So whatever is related with immovable property, any other right to or interest in. You may have interest as lessee of the property. You may have interest as mortgagee of the property. You may have interest as a tenant in the property. So if it relates to immovable property and the suit is required to be filed for that interest, so then in that case, where will you file the suit? That is the question. It says that the suit shall be filed at the place where the property is. Is this clear? Let me see the class also. So, suits for determination of any other right to or interest in immovable property. Suits for compensation for wrong. Suit for compensation to wrong. Now, maybe trespass, maybe nuisance. Suit for compensation for wrong to immovable property. I said like nuisance. Somebody is disturbing your peaceful possession and enjoyment of your right in that property, or trespass. Suit for compensation for wrong to immovable property. Then suit for recovery. Suit for recovery of movable property actually under distrent or attachment. Distrent or attachment. Sometimes your movable property may be under some distrent or attachment. What is this distrent? Let me tell you. Now, you might have heard an expression, distress, damage, feasant. Now, sometimes some animal comes to your land and destroys your crops, etc. You might have heard this. So, in that case, distress, damage, feasant. In that case, what happens? Suit for recovery of movable property actually under distrent or attachment. Recovery of movable property actually under distrent or attachment. Distress, damage, feasant. Distress, damage, feasant. Now, distress, damage, feasant means where you take possession of that animal which has caused damage to your property and you retain it. You possess it for the time being, unless and until your compensation is paid or damage is paid. So that is what is basically distress, damage, feasant. So unless and until you are compensated, you will not return this animal. And this is how you can cause pressure and cause some kind of force on that person who is possessing that animal to pay the money. Somebody might be owning that animal. So if animal has somehow destroyed your crops by entering into your farm, etc., then obviously you will hold that animal till your payment is made. So that is the kind of situation contemplated here. Suit for recovery of movable property actually under distrent. So this is movable property, that animal, and they are under distrent or attachment. Many properties are attached with the help of court or by the order of court, so that is also situation covered here. Shall be instituted in the court within local limits of whose jurisdiction the property is situate. So, where the suit will lie? Suit will lie at the place where property is situated. This is very general, very logical, very genuine provision which says that the suit relating to real property should lie at the place where the property is situated. Obviously so. Proviso says that a suit to obtain relief respecting or compensation for wrong to real property held by or on behalf of defendant may, where the relief sought can be entirely obtained through his personal obedience. Now, entirely obtained through his personal obedience, what does it mean? I'll explain to you. be instituted either in the court within the local limits of jurisdiction the property is situated, so property will remain the place where jurisdiction is there, or in the court within the local limits of whose jurisdiction the defendant actually and voluntarily resides, because in this case the relief can be obtained through his personal obedience also. So if it can be obtained through his personal obedience, where property is not to be taken care of in the sense that execution of decree is not against property as such, it is against that person, or it is against his money or against his interest. So the person is in question, the person is in issue, and I can obtain my relief through executing the law against that person exactly. So in that case, why not to catch that person at that particular place, and why not that court where that person actually and voluntarily resides will have jurisdiction? Because the court will give direction to that person to follow particular things. It can be obtained through his personal obedience. So obviously the court where he resides and where he carries on his business or where he works for gain, that court will have jurisdiction, because he can be found easily there, though the property may be situated somewhere else. So section 16 proviso in that sense extends jurisdiction one step further. It extends jurisdiction. It says if the relief can be obtained by personal obedience of the defendant, then that court will also have jurisdiction. So it says be instituted either in the court within the local jurisdiction of whose the property is situated, this is one, or in the court within the local limits of whose jurisdiction the defendant actually and voluntarily resides, or carries on business, or personally works for gain. Now, what is the meaning of this carries on business, or personally works for gain, or actually and voluntarily resides? We'll understand this just now. So section 16 is very simple provision. We say that the suit will lie at the place where property is situated. In which cases? In cases relating to immovable property. इसी को मैं हिंदी में बोल दूं संक्षेप में, तो सेक्शन 16, सेक्शन 15 ने तो कह दिया वही लोवेस्ट कोर्ट में जाओ, सेक्शन 15 ने कहा. 16 सेड भाई देखो जहां प्रॉपर्टी है वहीं सूट लाई करना चाहिए. इट इज सूट रिलेटेड टू प्रॉपर्टी. व्हाट कैन बी सूट रिलेटेड टू प्रॉपर्टी? कौन सा सूट प्रॉपर्टी रिलेटेड होगा? तो देन इट सेज रिकवरी, where you want to recover the property; partition, where you want to divide the property among the members; foreclosure, sale and redemption. I have already told you that in case of mortgage there can be foreclosure where you deprive somebody to get back possession of his property; sale, where you sell the property ultimately to obtain your money; and redemption, where you have right to get back your property. That is what is redeem. Get back your property when the payment is made. And then other right or interest in immovable property. Other right or interest in immovable property will mean your right to pass through that particular land, or your right to receive water from that particular place, or your right to receive some profit of that property. No, something like that. Then it says damages for wrong to immovable property. So damages for wrong to immovable property, as I have explained, there can be nuisance, there can be now some kind of trespass, that is damage to immovable property, or you can cause certain loss by demolishing the wall, etc. And last but not the least, it says recovery of even movable property under distress or attachment. So if movable property is under distress or attachment, then in that case also the suit will lie where the property is situated. So I don't think you should have any doubt here, but proviso is a little bit concerned, because provided that a suit to obtain relief respecting or compensation for wrong to immovable property held by or on behalf of the defendant may, where the relief sought can be obtained through his personal obedience. So it is very important to know that what is this where relief can be sought obtained through the personal obedience. What is the meaning of this expression, where relief can be obtained through personal obedience? So let us understand. This can be understood with the help of an example. I have a case also. This is S. Kumar Investment in Properties versus DD Resorts Private Limited. This is of High Court, Delhi, 2009. So on section 16 proviso, personal obedience. Now personal obedience under section 16 CPC. What is this personal obedience? Let us see. The plaintiff has sought relief of injunction in respect of suit property of which he is in possession, situated in Gurgaon, and that alleged conduct of defendant amounts to disturbing his possession. This court has territorial jurisdiction to try the suit, as the relief sought is such which can be obtained through personal obedience of defendant. Para 14. Plaintiff has, first you write down the name of the case. The name of the case is not very important, but you can write down. If you want to read, you can read. S. Kumar, Investment in Properties versus DD Resorts Private Limited. Here, plaintiff sought injunction against defendant. Here plaintiff sought injunction against defendant. Here plaintiff sought injunction against defendant restraining him to create any disturbance in peaceful enjoyment of property. So against whom you have sought this relief of injunction? Against defendant, not against property. You do not file a suit of injunction against property. You file a suit against injunction or a suit of injunction against defendant. So this is personal obedience of defendant by which this thing can be, or the relief can be obtained by personal obedience only. He is being restrained. That see, now if I am allowed to read further, in this case what has happened, defendant has already executed a conveyance deed. So he has already given the property to plaintiff, and it has been registered also, and also gave the possession of property to the plaintiff. But he did not measure the land exactly and actually, and now what he does, he has given possession of property to the plaintiff. He has given the property to the plaintiff through conveyance deed which was registered. So everything is complete, conveyance is complete, property goes to plaintiff. But as there is no actual measurement of land on the earth, land on the ground exactly, so which particular part of the land is there, it is not actually measured. So defendant generally interferes or disturbs his ingress and egress. Ingress, that is entry, egress, that is exit. So entry or exit of plaintiff is being disturbed by the defendant. Now plaintiff wants to file a permanent and mandatory injunction against this defendant that he should not be allowed to disturb my entry and exit in this property because I have already bought this property from him and the deed is registered. I am in physical possession of property also, so he should not be allowed to disturb my possession and interfere with my right or use or enjoyment of this particular land. So against whom you are seeking injunction? Against defendant, not against property. So it can be obtained through personal, now obedience only. This is S. Kumar Investment and Properties versus DD Resorts Private Limited. This is decision of Delhi High Court on 21/10/2009. Civil suit, original side 1757/2009. 1757/2009. So this is case number 1757 of 2009 basically. So as the relief can be obtained by personal obedience of defendant, as the relief can be obtained by personal obedience of defendant, then the suit can be filed at the place of defendant as well. This is in addition to the place where the suit can be filed. No? Now in this case you see property is in Gurgaon. Conveyance deed was executed in Gurgaon. Conveyance deed was executed in Gurgaon. Plaintiff filed suit in Delhi. Payment was given to defendant's Delhi office. Payment was given to defendant in Delhi office. In defendant's Delhi office. And defendant works here. Defendant works here. Defendant works here. Defendant has office here. I will read certain paragraph and I will send you in app also this case. Suit in relation to, now I'll give you a little bit more on this point. This court has territorial jurisdiction to try the suit as the relief sought is such which can be obtained through personal obedience of the defendant. It would be apposite to reproduce, apposite means appropriate to reproduce the relevant paragraph of Bhavana set. On consideration of the aforesaid judgment, I am of the view that there can be no doubt wherein suit for a specific performance possession is also claimed as a relief. The competent court to deal with the matter is the court where the property is located in view of section 16. And on this point, Harshad Chimanlal Modi versus DLF Universal and others Limited very clearly says this. Because it is suit for a specific performance as well as suit for possession. But in Bhavana set, judgment have been discussed, including judgment on which defendant has relied. Legal proposition which has been culled out from them is that there is distinction between suit in relation to specific performance of agreement in question without relief of possession and in suit where additional relief for delivery of possession is also paid. In the latter case, the legal decision has ousted the jurisdiction of court whereof the suit property is not situated, where in the earlier cases, Adcon Electronics is squarely applies. Now, so now I would add here, I hope this case is clear. I would add in this point here, this is how questions are generated. This is how questions are generated. So you can note down this. This is Bhavana set versus DLF. Bhavana set versus DLF. 2007 decision. Bhavana set versus DLF. This is DLT 2007. If you want to read this case, I give you citation 138 2007 DLT 639. Now, there is distinction between, I give you very clear picture, there is distinction between suit relating to specific performance, suit relating to specific performance of agreement plus, or rather right here, without claiming possession. And the same suit with claim of possession. Now here you are claiming possession, here you are not claiming possession. So they say, in the latter cases, the legal decision has outside the jurisdiction of court where suit property is not situated. So if you claim possession, court where suit property is not situated will not have jurisdiction. Will not have jurisdiction. I write it a little clearly. Same suit with claim of possession. So in this case, court where property is not situated will not have jurisdiction. And correctly so. Because how will you grant possession which is not there in your jurisdiction, in your area? So it is always better to knock the court which has authority over the property, in whose jurisdiction there is property. Because I am claiming possession also. The relief of possession can be granted better by the court where the property is situated. So so the law is there that in such case, court where property is not situated, property is not situated, will not have jurisdiction. But this is not here. In such case, that court can also have jurisdiction. So I hope you understand this. Without claiming a relief of possession. Court where property is not situated, even that court can have jurisdiction. Just see beauty of the decision, because you are not required to grant to possession. So property is situated or not, a specific performance is almost like a contract. So you are claiming the performance of contract. Who will perform the contract? The party concerned. So it can be even at that place where party is present, where he actually works for gain, or where he actually involuntarily resides, where he personally works for gain, where he carries on business, even that court will have jurisdiction. Because it requires personal obedience. In the first case, it requires personal obedience. So if personal obedience is required, then the party where he is living, the defendant living, because you are compelling defendant to be there, defendant to follow this. Adcon Electronics Private Limited versus Daulat. Arshad Chimanlal Modi versus DLF Universal and another. Arshad Chimanlal Modi versus DLF Universal and another. AIR 2005, Supreme Court 4446. Arshad Chimanlal Modi versus DLF Universal and another. The court said, where in a suit for a specific performance, possession is also claimed as a relief the competent court to deal with the matter is the court the competent court to deal with the matter is a court where property is located. Where property is located in view of section 16. In view of section 16. Possession is also claimed. The competent court will be court where the property is located. Court where property is located. I hope you understand this point very simply, clearly. Adcon, Electronics Private Limited versus Daulat and others. This is 2001, 7 SCC, page 69. You are not required to remember the name of cases at all. Don't be disturbed by this fact. I am referring this just for your reference. Even when you become a judge, you can refer these cases and you can see this, even as a lawyer, but not as a student, my dear friend. But you should know the law. From where we got the law, you should know the source. But you are not required to memorize the source always. Here also they said, in a suit for a specific performance, sense possession, sense means without. Sense possession, the court provided in proviso. Proviso says na, where defendant resides. Proviso of section 16 will have jurisdiction. Will have jurisdiction. Will have jurisdiction. Is this clear? Will have jurisdiction. Arshad Chimanlal Modi, I have said this. Then I'll come to other cases. Just have 5 minutes break, please. Then we'll begin and we'll discuss this point further. I'm raising a question on your behalf so that you can understand the law. Now it says in proviso, where relief sought can be entirely obtained through his personal obedience. That you understand. That you understand. That you understand. Now it says further, whose jurisdiction the defendant actually and voluntarily resides. What is the meaning of this expression, actually and voluntarily? Actually basically refers to the situation where he should be residing there in reality, not constructively. Like you have key of the house or something like that, that is constructive possession, not constructively. Actually and voluntarily, voluntarily, not under duress. Voluntarily, not under compulsion. Or carries on business. Now business should be carried on and it should be business, not anything and everything. Now suppose we are doing business here in Delhi and I am producing certain goods here and I have my offices here, but I am supplying goods all over India. Am I doing business all over India? The answer is no. I am doing business in Delhi. You are producing goods here, you are receiving orders here, you are dispatching goods from here. All transactions are taking place here in Delhi. I'm receiving money in Delhi, my account is in Delhi, my office is in Delhi, my production center is in Delhi, my dispatch center is in Delhi, but I'm supplying goods at various places in India. Am I doing business in whole India? The answer is no. So carries on business. And then it's a third says, personally works for gain. Now, personally works for gain. What is the meaning of this expression? What is the meaning of this expression? Now, it says personally works for gain. So it doesn't say that it should be gain only. No, not gain only. Like now, somebody somewhere, Panditji goes and receives some kind of alms or some kind of gift from somewhere. Is it personally working for gain? No, he's gaining, but there is no work. So he personally, not through somebody, works, and then gain is there. That is how it is attracted. So if I am personally working, I am personally teaching in this class, and I am working here for gain. So my situation will qualify this section 16, or section 16 will cover my situation. If I only gain, suppose you have become a judge, or you have topped judicial examination, now you give me gift of Mercedes car or gift of now anything, BMW 7 Series, something like that, or Tesla, whatever. You give me that. So have I, now in that situation, have I personally worked for gain? Personally working for gain is now teaching in the class. I am working here, I will gain some money, institute will pay me some amount for teaching here. So that is what is personally working for gain. It is not gain only, but in that case of gift, it is gain only. In case of alms or gift, it is gain only. It is not personally working for gain. In this case, property means property situated in India. It will not apply to property situated outside, that you can say that uh, the property is situated in Karachi, so Karachi court will have jurisdiction. So that is not the idea here, my dear friend. So I hope section 16 is clear to you. Now section 16 should be clear to you. Now then there is further, there is an observation of Supreme Court, and Supreme Court says that the principle is hmm, everything all right? Somebody has written, voice is breaking. Is it so? Hmm. The Supreme Court said that action against property should be brought in the forum where the property is situated. That is perfectly all right. In other words, court has no jurisdiction over a dispute where it cannot give an effective judgment. Where it cannot give an effective judgment. So effective judgment will be possible only in case where you can have better execution of the decree. And better execution of the decree will depend on the fact whether the property is situated here or not. Now then further observation, proviso to section 16 is based on well-known maxim, that is, equity acts in personam. Equity acts in personam, which has been recognized in English courts. Equity acts in personam. Now I must tell you that equity courts had jurisdiction. Now equity courts had jurisdiction to entertain suits equity court had the jurisdiction to entertain suits respecting immovable property, situated abroad. Situated abroad by enforcing their judgment, situated abroad by enforcing their judgment. Now, by enforcing their judgment by enforcing their judgment by process in personam. As the property is situated outside, so how can you do something with the property? So what they did in alternative, that they started doing this now in personam. That is by personal obedience in that sense. So I said, equity courts had jurisdiction to entertain respecting suits of immovable property situated abroad through personal evidence. The principle was that the court can grant relief in suits related to immovable property situated abroad by enforcing their judgment by process in personam. That is, process in personam means what? That is, by arrest of defendant or attachment of his property, which is in my jurisdiction. So I can order for his arrest, or I can by process in personam, that is by arrest of defendant, or by attachment of his property, or by attachment of his property. The court of equity which is also known as court of conscience. Court of conscience, and it operates in personam and not in rem. And in exercise of their personal jurisdiction, and in exercise of their personal jurisdiction, they have always been involved. They have always been involved in compelling performance of contract in which subject or property were not locally within their jurisdiction. 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 Main provision is centered towards property, whereas proviso is centric towards defendant. Main provision is towards property and proviso is towards defendant. You can see this very clearly. But proviso, which is exception, cannot override the main provision which will apply. So you can write down even this. Have you written this all? Main provision is property centric, whereas proviso is defendant centric. Whereas proviso, but proviso is in form of exception. Proviso is in form of exception. So it cannot override or enlarge the scope of principal provision. Now, so it cannot override the scope of, just here, not enlarge. It obviously enlarges. So it cannot override the scope of principal provision. It cannot override the scope of, in other words, it will apply only if case falls in principal provision. It will apply only if case falls in principal provision. It will apply only if case falls in principal provision. Now, so if in a case property is situated in, so if in any case property is situated in Noida, can we file a suit for a specific performance related to that property, where even possession is demanded, possession is demanded in Delhi? The answer is no. Where possession is also demanded, the answer is no. Property is situated in Noida, so better court is Noida. Though the jurisdiction may be with the Delhi court also, but which is the better court, you are required to see even this. We are required to interpret law in such a way that we can have best enforcement of law. 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 Is this clear? I hope we have covered section 16. Section 17 will apply when there are several jurisdictions. So you can now further write down Section 17 will apply. Section 16 will apply when there are several jurisdictions, out of which one or more property is situated in one jurisdiction, other in other jurisdiction. If substantial portion of property is situated in one jurisdiction and insignificant portion in another, then Section 17 will apply when there are several places where property is situated. Where property is situated, then all the courts of different places will have jurisdiction. Then all courts of different places will have jurisdiction. If substantial portion is situated at one place A and insignificant portion is located at another place B, located at another place B, then the court having substantial portion of property will be better jurisdiction to deal with the case. Will be better jurisdiction to deal with the case. Will be better jurisdiction to deal with the case. Will be better jurisdiction to deal with the case. Will be better jurisdiction to deal with the case. When jurisdiction is uncertain, where the suit should lie. When jurisdiction is uncertain, Section 18. See, territorial jurisdiction is point of convenience. Section 18 says, if I can read this, when it is alleged to be uncertain within the local limits of jurisdiction of which of the two or more courts any movable property is situated, whether it is situated in this court or that court, any one of those courts may, if satisfied that there is ground for alleged uncertainty, record a statement to that effect. So any one of those courts, and thereupon proceed to entertain and dispose of any suit relating, and its decree in the suit shall have the same fact as if the property were situated within the local limits of its jurisdiction, provided that the suit is one with respect to which the court is competent as regards the nature and value of the suit to exercise jurisdiction. When a statement has been recorded under subsection 1 and an objection is taken before an appellate or revisional court, that a decree or order now was made in a court not having jurisdiction where the property is situated, the appellate or revisional court shall not allow the objection, unless in its opinion there was at the time no reasonable ground for uncertainty as to the court having jurisdiction with respect thereto, and there has been a consequent failure of justice. So, only ground where they can allow to raise objection that there was no reasonable ground for uncertainty and there has been consequent failure. So, if these twin conditions are satisfied, then appellate and revisional court may interfere, otherwise, no. So, suppose property is here, property X is here, and suppose now I say that this is area A and this is area B, and this is a course of river. Suppose this is the river, this is the river, suppose, or some kind of water source which is flowing here. Now it changes its course. Now one person says that this river was the dividing line between area A and area B. Now this river has changed the course, so this has gone in area B. But other people say that no, this river was indication of area, but the area remains same and it is area A. So one says it is area B and another says it is area A, because the river course is the dividing line and river has changed its course. Earlier it was like this, earlier it was like this, and now it is like this. So they say that this river course is the area. But the other person says, no, a river course was the indicative, area remains same. So there is alleged uncertainty. Court also agreed to this point that there can be such situation. So section 18 says, now in this context you will write down that in case of uncertainty of jurisdiction, that where immovable property lies, in case of uncertainty of jurisdiction where immovable property lies, and there is ground of alleged uncertainty as well. In case of uncertainty of jurisdiction, that where immovable property lies and there is ground of alleged uncertainty as well. Ground is there. Ground of alleged uncertainty as well. Ground of alleged uncertainty as well. So in that situation, in case of uncertainty that where immovable property lies and there is ground of alleged uncertainty as well. So in that case, the court can record. In that case, court can record. So in that case, the court can record that ground. So in that case, the court can record that ground. The court can record the ground and can entertain. The court can record the ground Court can record that ground and can entertain the suit and can exercise jurisdiction. Court can record the ground, and then I am going further. Then I am writing here, court can record that ground and the court can exercise jurisdiction. The court can exercise jurisdiction. The court can exercise jurisdiction. Court can exercise jurisdiction. Court can exercise jurisdiction. The court can exercise jurisdiction. As if the property is situate within its jurisdiction. As if situate within its jurisdiction, provided it is competent as far as the value of the property is concerned. Next, if a statement is not recorded to that effect, if a statement is not recorded to that effect and objection is taken at appellate and revisional court, and then the court will not allow objection unless it is shown that, number one, that there was no reasonable ground for objection. There was no reasonable ground for objection. And number two, there was no reasonable ground for uncertainty. There was no reasonable ground for uncertainty. And number two, there was no unreasonable ground for uncertainty, and there has been consequent failure of no reasonable ground for uncertainty, and there has been consequent failure of justice. There was no reasonable ground for uncertainty, and there has been consequent failure of justice. There has been consequent failure of justice. So these two conditions must be satisfied. Consequent failure of justice and no reasonable ground for uncertainty. Then only the appellate or revisional court will interfere, otherwise they are not going to interfere. If there is ground for uncertainty and there has been no consequent failure of justice, why should we? If there is ground for uncertainty and if there has been consequent failure of justice, why should we entertain the objection now? Is this clear? Now see section 19. The suit for compensation for wrongs to person or movables. Suit for compensation for wrongs to person or movable. Section 19. It provides for alternative jurisdiction. What is that alternative? Let us see this section 19. It says, where a suit is for compensation for wrong done to person. There can be certain wrong which can be done to person, like defamation is there, now, injury is there, assault and battery in tort law, wrong to persons, or movable property. It provides alternative jurisdiction. What it says, where a suit is for compensation for wrong done to person or to movable, if the wrong was done within the local limit of jurisdiction of one court, wrong is done at one court, and defendant resides or carries on business or personally works for gain within the local limit of jurisdiction of another court, the suit may be instituted at the option of the plaintiff in either. So, which courts? It says two courts. Uh, it There are two courts which can have jurisdiction. Two courts. Number one, the wrong was done within where wrong was done. Number two, where wrong was done. And number two, where defendant resides or carries on business where defendant resides, carries on business, personally works for gain. So both courts, where wrong was done, in that court, if these are different courts, and where defendant resides, even in that court. So if wrong was done in A court and defendant resides or carries on business, here it is defendant resides. Here there is no actually and voluntarily, just see, preliminary question. Only defendant resides. It can be actually and it can be constructively, both cases. Now illustrations are there also. A residing in Delhi, bits B in Calcutta. So where the wrong was done? In Calcutta. And where A resides? Delhi. B may sue A either in Calcutta where wrong was done or in Delhi where he resides. Illustration B, A residing in Delhi publishes in Calcutta a statement defamatory of B. So statement was published as defamatory in Calcutta. So B may sue either in Calcutta or in Delhi. So section 19 was simple. You must have understood all other sections, I hope so. Now section 17 talks about where there are different properties situated at different place. बहुत सारी प्रॉपर्टी है आपकी और कहीं नोएडा में, गुड़गांव में, दिल्ली में, तो कहाँ ज्यूरिसडिक्शन होगा? सभी कोर्ट्स में होगा. दैट इज सेक्शन 17. 18 says uncertainty. आई एम नॉट क्लियर वेदर इट इज नोएडा और दिल्ली. तो इन दैट केस आई कैन फाइल ए सूट. दिल्ली में भी कर सकते हैं, नोएडा में भी कर सकते हैं, क्योंकि कन्फ्यूजन है हमें किस कोर्ट में. बट आपको उसका जस्टिफिकेशन देना पड़ेगा, ग्राउंड बताना पड़ेगा. आप सिंपल लैंग्वेज है, बहुत सिंपल है, पढ़ लीजिए. दिस इज वेरी सिंपल, आई होप सो. बट देखो समझदारी है कि ना, सपोज करो कि आई हैव प्रॉपर्टी ऑफ 100 करोड़ इन नोएडा, आई हैव प्रॉपर्टी ऑफ 95 करोड़ and I have property in Delhi of 5 crore. So which court will have better jurisdiction? Noida court, because most of the property is situated there in Noida court. Is this clear? Where dependent resides, carries on business, personally works for gain, in that court. A residing in Delhi publishes in Calcutta statements defamatory of B. B may sue either in Calcutta or in Delhi. Section 20. Section 20. So section 20, can you see section 20? बेटर होगा यदि 5 मिनट के लिए रुकेंगे तो अच्छा रहेगा. सेक्शन 20 is a little lengthy section and it requires little bit understanding. Section 20 is very meaningful and very important section also. So if we stop for 5 minutes, it will be better. You have breather, then I'll explain section 20 in one go. Is this clear? And that is how we will complete today's things. Section 20. If you have any doubt or question, please reserve it for the last and you please ask me towards the end. Is this clear? So I take 5 minutes. वो रह गई. So let us see section 20. Other suits to be instituted where defendants reside or cause of action arises. Other suits. Other suits. Other suits. तो movable person वाला पढ़ लिया आपने. You have read about this uncertainty also. You talked about immovable property as well. Now, other suits, like there may be suit relating to contract. But there are many suits which are not coming within the scope of these sections. The reason being but obvious. The reason being but obvious. For interruption. So I said other suits. Other suits क्या हो सकता है? So other suits will mean that which is not covered in 16, 17, 18, 19, other suits. So immovable property we have read in section 16, then 19 we talked about movable and persons, other suits. Maybe contract as I said. I gave an example, that can be, but I want to clarify one more point which I said, that there may be many suits which will not come within this province, because they are expressly, covered somewhere else, like matrimonial disputes. You have Hindu Marriage Act and section 19 is there. Family Courts Act is there. Family Courts Act describe jurisdiction and judges regarding those matrimonial disputes and other disputes related to family affairs. So in those cases, these provisions doesn't apply, that they will be covered by those provisions. Is this clear? Like Negotiable Instrument Act. Now in Negotiable Instrument Act regarding bouncing of checks, we discussed the situation there. We talk about Negotiable Instrument Act jurisdiction there. We do not talk about this general provision. So that has to be taken care of. So now in other suits, where the suit will lie. So section 20 says, subject to limitations aforesaid, every suit shall be instituted in court within local limits of whose jurisdiction. So where the in case of other suits, suit will lie, number one, within local limits. Within local limits of whose jurisdiction, within local limits of whose jurisdiction a defendant or defendants at the time of commencement of suit. So it is to be seen at the time of commencement of suit, when the suit began, commencement of suit. A actually and voluntarily resides. B carries on business. C personally works for gain. Actually and voluntarily resides, carries. So, defendant, wherever he resides, actually and voluntarily carries on business, you understand these terms. That place will have jurisdiction. Any of the defendants where there are more than one at the time of commencement, actually, and where there are any. So, if this is case of one defendant, this is the repetition. So, in other suits, the court where, number one, defendant resides or does business, in simple language you can write, or work for gain, or any of the defendant resides, does business, or work for gain. Any of the defendants. So there are various jurisdictions now. Suppose there are 4 defendants, A, B, C, D, and they reside at one place, carries business another place, work for gain another place. So in all these cases, there are 4 defendants. Suppose there are 4 different places. Now, so for them this is 3, for them this is 3, for them this is 3. So this is 3, 3, 3, 3. So this is now 12 places of jurisdiction. If they are all different courts, 12 places of jurisdiction. So it multiplies jurisdiction, it provides many alternative forums, many alternative places of jurisdiction. And it requires liberal construction. So if dependent A is in Delhi, works in Delhi, resides in Gurgaon, and he carries on business in Noida, so all these 3 places. Similarly, B may be situated in Bombay, and his business may be in Goa, and he works also in Nagpur. Maybe various situations we are contemplating that. So it says, but in this case where there are multiple defendants, there will be now some conflict between these 4. Obviously, everybody wants that the suit should be filed at his place. So it says, provided that in such case either the leave of the court is given. So where there are multiple defendants, you are required to seek leave of the court, or the defendants who do not reside, they acquiesce in such institution. So I will clarify further. In case of multiple defendants, either the court's permission or acquiescence of other defendants are required. So other defendants should acquiesce in this, or the court permission should have been sought. Now, number 3, it says the cause of action wholly or in part arises. So that is the place of jurisdiction. Now the court where cause of action arises wholly or in part. We'll understand it. Now, like for example, you see, works for gain actually and voluntarily resides and personally works for gain, or this carries on business, I don't think that they will pose any problem to you, because this is simple general. This is simple general. Is this clear? The cause of action wholly or in partly. A corporation shall be deemed to carry on business as its sole. So what is carries on business? This is clarified in explanation. Corporation shall be deemed to carry on business at its sole or principal office in India, or in respect of any cause of action arising at any place where it has also a subordinate office at such place. So if it has sole or principal office in India, that is the place of business. Or if it has any subordinate office and cause of action has a region there, so that is the place of business. So there is further clarification of place of business. Place of business in case of corporation. In case of corporation. So what is the clarification? So let me write this. Corporation has deemed to carry on business at its sole or principal office. So sole or principal office. If you have only one office, then that is the place. That is the place. Or principal. So if you have many offices, then the principal office. Sole means single. single office. So there is no confusion. And principal means many offices. There are many offices in India. Then principal office. That is clear. So you have offices at A, B, Ahmedabad, Bombay, Calcutta, Delhi. But where is your principal office? Principal of Ahmedabad, I said Bombay, Chennai, Delhi. Chennai, this is Chennai. Delhi. Bangalore, Mumbai is now not Bombay. This is Ahmedabad, I said. So you have many offices. But which is the principal office? Delhi. So where the jurisdiction will lie? Delhi. This is what is general. Delhi is principal office. Principal office is at Delhi. Principal office at Delhi. So Delhi will have jurisdiction. Is this clear? So just see this carefully. Is this all right? And then see this. I said this is principal or sole office, no issue. And then there is very important clarification or in respect of any cause of action arising at any place where it has also a subordinate office at such place. So now you mind it, it's very important point which we are going to now write down. So I just remove this and then I write it further. Number 2. In respect of any cause of action arising at any place where it has also a subordinate office. If it has a subordinate office, in respect of any cause of action arising, and cause of action arises there, then jurisdiction will be at and if it has a subordinate office and cause of action arises at subordinate place, then jurisdiction will be at subordinate place. Then jurisdiction will be at subordinate place. Is this clear? आप लोग इतना ग्रुप में लिखता क्यों है भाई? पढ़ने पे ध्यान दो यार, गजब लिखते रहते हो आप लोग. So if it has a subordinate office and cause of action arises at subordinate office, now subordinate office, then that is the place. Cause of action arises at subordinate office. Cause of action arises at subordinate office, then jurisdiction will be at subordinate office. Then jurisdiction will be at subordinate office. If it has a subordinate office and cause of action arises at subordinate, then the jurisdiction will be at subordinate office. Now, you may understand a very simple point. Let's see, if there is sole or principal office, I write it in my language. I have I write it in very simple language. Suppose corporation has, number one, cause of action arises, place of suing. Clear? Corporation has sole office, single office, single solitary. Cause of action arises anywhere. Place of suing, sole office. Corporation has principal office, that is main office, plus subordinate office. Clear? Cause of action arises at principal office. No confusion. No confusion. Where the place of jurisdiction will be? Principal office. Just see it carefully. It's very simple. Or at any place, but not at subordinate office. Not at subordinate office. So again, the place of jurisdiction is principal office. But suppose in the same situation, cause of action arises at subordinate office. Just see. So where the place of jurisdiction will be? Subordinate office. This is what you are required to understand. See this picture carefully. Corporation has sole office, no confusion, cause of action arises anywhere, place of suing anywhere. Oh, sole office. Corporation has principal office, like I said, Delhi. And there are other subordinate office, A, B, C. And not at subordinate office. The cause of action arises at principal office, let us say Delhi. So Delhi will have jurisdiction. At any place, but not at our subordinate office. So it is not at A, B, C. It is at E. So again it is principal office. But if it is arisen at subordinate office A, B, C, then the jurisdiction will be at A, B, C, not D, that is principal office. Delhi is principal office, not D. This is what is very, very important in section 20 explanation. Very, very important in section 20 explanation. But this is very simple. This is very simple. You see this picture. You see this picture carefully. In the second illustration, you have principal office at Delhi and subordinate office at A or B or C. The cause of action arises at Delhi. So Delhi will have jurisdiction, principal office. Cause of action arises not at subordinate office ABC, but arises at E, where there is no subordinate office. So again, jurisdiction will be at principal office, that is D. But in same situation where there is principal office and subordinate office and cause of action arises at subordinate office, then subordinate office ABC will have jurisdiction and not principal office Delhi. This is what is my humble submission. You can write this in your language also. So place of business you understand now, I hope. Place of business you understand. Now we are understanding place of business. Let us understand little bit cause of this carries on business also, or this uh, cause of action as well. That is how will we understand the section 20 better. Carries on business. It means business is running or going on. Write down. It means business is running or going on. It also indicates that it is not isolated, individual, solitary activity. Rather, it connotes the idea of continuity. Carries on business, which may be even for a short period of time. It may not be a permanent business. There can be a single venture also, like making of a film. Film making is a single venture business. Single venture business. But it is business. We are doing this activity for making profit. Business is basically meant for making profit. You might have read commercial laws. Railway runs all across the country. If a person faces problem in railway, then do we need to file a suit in Delhi because railway headquarters is in Delhi? No, that is not reasonable and justifiable. The person can file suit in local jurisdiction where cause of action arose. The principle will apply to every company who have all India operations. So, I gave an example. There is an example in your Bear Act also, that railway is having its operation all over India, and it carries passenger and goods all over India. So, if anywhere any problem arises, should we reach to Delhi to file a case against railway that railway headquarters is in Delhi? The answer is no. It is carrying on business over entire India, and it has place of business over entire India, and it has many zonal headquarters. You might be knowing there are many zones of railway. So why we will come to Delhi? You go to that subordinate office where cause of action arose. This is not practicable practical also, that you come to Delhi in all cases to file a suit. No, no, no. This principle will apply to all those companies who have all India operation as well. See the illustration. A tradesman in Calcutta, B carries on business in Delhi. B, by his agent in Calcutta, buys goods of A and requests A to deliver them to East India Company, East Indian Railway Company. A delivers the goods accordingly in Calcutta. A may sue B for the price of goods either in Calcutta, where cause of action has arisen, or in Delhi, where B carries on business. Obviously, cause of action has arisen in Calcutta, because A is tradesman in Calcutta, and B, by his agent in Calcutta, buys goods of A. So, where the goods have been bought? In Calcutta. Request A to deliver them where? To East India Company in Calcutta. See, buying of goods in Calcutta, delivery of goods in Calcutta, and A, who is the supplier, he is in Calcutta. Is this clear? A delivers the goods in Calcutta. A may sue. So, where A will sue B for price? So, A will sue B for price in Calcutta, where cause of action arose. Cause of action is bundle of facts which gives rise to an action. So buying of goods and delivery of goods is the reason for payment. If you have bought goods in Calcutta, you must make payment then and there, and your goods have also been given. But you have taken this on credit, so you are required to pay it now. A will sue B for price in Calcutta, number one, or number two, क्या उल्टा पुल्टा खोल क्या आ गया अरे कहाँ चला गया ये देखो भाई कहाँ चला गया ये पेज है तो पेज कहाँ गया हाँ यहाँ नीचे से भी आता है फिर अपने आप को अपडेट करो So I said the goods were delivered in Calcutta, bought in Calcutta. So every activity has happened there. And B is residing in Delhi. So B is defendant. Because A will file case, so B is defendant. B is residing in Delhi. So as per section 20, where can you file the case? Where defendant resides, or where he carries on business, or where cause of action arose. So cause of action arose in Calcutta. So this is one place, and B resides in Delhi. So that is also a place of jurisdiction. Similarly, see this illustration B, which has been asked in your examination again and again. Again and again. A resides at Simla. B at Calcutta. C at Delhi. A, B and C being together at Banaras. B and C make a joint promissory note payable on demand and deliver it to A. A may sue B and C at Banaras. So this is the place where everything happened. Make a joint promissory note and deliver it to A. This is the place, Banaras. So this happens in Banaras. The cause of action arises in Banaras also, where cause of action arose. He may also sue them at Calcutta. Why? Because B resides at Calcutta and at Delhi, where C resides. But if in all of these cases, if non-resident dependent object, suit cannot proceed without the leave of court. So cause of action arises in Banaras. So suit will lie here, no doubt. Banaras will have place of jurisdiction. And where B resides? B resides at Calcutta. So Calcutta can have jurisdiction. And C resides at Delhi. So Delhi can have jurisdiction. So Delhi will have jurisdiction, Calcutta will have jurisdiction, Banaras will have jurisdiction. Banaras on the basis of cause of action and Delhi and Calcutta on the basis of residence. But if you choose either Delhi or Calcutta and other party objects like C objects, if you choose Calcutta, so unless and until you seek permission of the court or C acquiesces, you cannot file suit at Calcutta. Is this clear? Is this all right? I think it is all right. I will stop here for the day and I will see you tomorrow. And tomorrow we'll take up all questions of jurisdiction. And I have requested you to solve question of Order 2, Rule 2, Order 7, Rule 11, Order 1, Order 1, Order 2, Order 7. You must solve all questions. And even Section 9. Section 9 questions we have solved, but you can solve even further questions. Now you can bring further things, and I have requested you to write questions in your WhatsApp group 9 to 9:30 in the morning, 9 to 9:30 in the evening. So even if I miss a question in the class, I'll be answering it there. And if I get question in advance, it will be obviously now better for me to answer the question in organized manner. So you please feel free to ask the questions. Is this clear? Order 1, Order 2, Order 4, Order 6, Order 7, plain drafting, parties to the suit, framing of the suit, Section 9, which is very, very important. Today we have discussed Section 16 to 20, and now tomorrow we'll be discussing objection as to jurisdiction, that is Section 21 to 25, and we'll discuss a little bit Section 20 also. We'll bring some more cases. And we'll discuss foreign judgment also, Section 12, 13, 14. So I am waiting for your questions. I will answer it one day or the other. Is this clear? So please solve the question. And if I now want to Aarti, have you read contract? क्वेश्चन तो आपने फॉर्मुलेट कर दिया हाइपोथेटिकल, बट कॉन्ट्रैक्ट पढ़ा है? जब भी कुछ टेलीफोन पे बोला जाता है तो कहाँ वो पब्लिश होता है, ये आपने पढ़ा है? इट इज एट द प्लेस वेयर इट इज हर्ड. तो जहाँ सुना गया, दैट इज द प्लेस ऑफ पब्लिकेशन. ठीक है? वेयर इट इज हर्ड, देयर द प्लेस ऑफ पब्लिकेशन. इट इज देयर इन कॉन्ट्रैक्ट एक्ट. पढ़ेंगे आप टेलीफोन केसेस. So I was just requesting you to solve the question and solve question of previous year. See, a hypothetical question will not benefit you much. Abhi aapko, it will give you some kind of thrill, excitement, enjoyment. But exam questions are exam question. So you solve a previous year question paper. I have told you, now we have a guide also of All India Judicial Services. So please see that, solve it. Read your own Bare Act, Read the cases, but don't memorize the cases unless until I tell you to memorize it. But just see the cases for understanding. And if you see the cases of lower courts, you will understand also judgment writing. Is this clear, my dear friend? And we'll solve question of jurisdiction tomorrow, because now we will be solving question along with the topics. But the left topics, that is order 2, order 1, order 7, order 6 and order 4, you solve the questions, and whatever queries and concerns you have, please write it in WhatsApp group. I will solve all of them. Is this all right? I hope it is. Yes. Thank you very much. God bless you.